I'm going to bring up Pat English, and he's got some real information, and we do have to vote on this when it comes to the federal ID change, which would allow the ABC to do suspensions on fighters that aren't licensed in certain jurisdictions. So with that, here you go, Pat.
Thank you. Thank you. Well, you will notice that there's a hat in front of me. That is a John McCain destroyer hat, and the president did not ask that the hat be moved before he just spoke, so I'd like to congratulate him on that. Some of you may know what I'm talking about. Okay, so despite popular opinion, I did not write, or was not part of writing the Constitution of the United States. I'm not quite that old, but I'm like Zelig. If you know who Zelig was, it was a Woody Allen movie. I have been around and been at many, many things. So I'm going to briefly go through, because if I don't be brief, Greg Serb is going to kill me. I'm going to go briefly through the history of federal regulation with a little bit of aside from time to time. And, of course, what's on the screen in front of me is not what is on the computer in front of me. So, I've prepared a brief outline, and it begins with the first modern federal issue with boxing. It was a federal case where the U.S. Attorney's Office brought mobs who were controlling boxing in the 50s in the late 40s into court. You know, you've all seen Raging Bull and seen the mob influence that existed, portrayed in that movie. Well, that's all true. I have a friend who remembers Blinky Palermo, who was a Philadelphia mobster, very, very well, and he controlled much of boxing through the International Boxing Club. Well, the way that the federal government attacked that was very similar to the way they attacked Al Capone. They didn't get Al Capone for racketeering, they got him for tax evasion. So the government went after the International Boxing Club for antitrust violations and were successful. And in many respects, in the antitrust field, it's a seminal case. But they broke up the mob cartels. The next aspect that's worthy of mention for federal intervention in boxing was the Kefauver hearings. Kefauver was a Tennessee senator. He wanted to run for president, and may have, I don't remember, but he held a whole series of hearings regarding mob influence in boxing. Now, what he did was essentially take the work of the Justice Department and publicize it. He also had certain safety concerns. He sponsored a bill for a national commission. He passed away before any of his proposed bills went through Congress. But when I first got involved in boxing, the Kefauver hearings were widely cited. They had a great influence. And frankly, from those hearings came the rise of the ratings organizations. I'm not going to go into that today, but after those hearings, the ratings organizations proliferated and thrived. There were, in the 1970s and 1980s, various federal proposals regarding boxing, proposed laws, but not one of them got any traction whatsoever. Which takes us to things that I were involved with. There was a controversial fight between Dave Tiberi and James Toney. It was held in New Jersey. I was not involved in that fight. But Senator Roth held hearings regarding boxing, and they were very well attended. And I was surprised. I was there. I represented a witness who was there as an expert witness, not as a sort of defensive witness. It was Dan Duva. And it was a hearing on things like conflicts of interest and health and safety. One of the things that surprised me, and I was there when it happened, was the head of the IBF at the time, a fellow named Bob Lee, who some of you may remember, was asked questions, and he ended up taking the fifth, which got a lot of publicity, as you might imagine. One of the side issues there was, I learned later in talking to the committee staff, that they told him what questions they were going to ask. And he had the option of not appearing, because that particular Senate committee had a process where if somebody was going to take the fifth, they just wouldn't call him. Well, he showed up. He didn't tell his attorney. He was represented by a prominent Washington attorney. Never told his attorney that he was going to take the fifth. When he did, it was quite a media sensation. Another thing that happened in the early 90s was, and this isn't on the outline in front of you, was that the unified rules were promulgated. Now, that's not a federal enactment, but I think it's worthy of just a brief mention of how that occurred. There were founding fathers of the unified rules. They included Greg, sitting in the back, Mark Ratner, and a number of, they're here, and a number of others who came into a meeting that was held in Atlantic City around the time of a undisputed title fight, meaning that all of the presidents of the sanctioning organizations were there. Others attended, I attended, and they presented proposed unified rules that were, as Greg suggests, 80% done. They were good. There was a lot of debate. Some of it was hot and heavy, but not really quite as hot and heavy as I recall it as the debate that you guys have been having and may still have regarding MMA. But people just sat there until they got done. And they were used in a fight. This was on a Friday. Texas had a fight that night. They used those rules at the fight that Friday. And they were used in the unified title championship the following Saturday, which to my recollection was an Evander Holyfield fight. So we were lucky in that people accepted the rules, something that hasn't been so fortunate in terms of MMA. That was very important, and it was a context of some later federal actions. It gave a lot of credence, a lot of credibility to the ABC, because it was the ABC that did that. The next federal action was the Professional Boxing Health and Safety Act, which has been forgotten because it's now part of the Muhammad Ali Act. The Muhammad Ali Act is actually an amendment to the Professional Boxing Health and Safety Act. Now, I'm going to come back to that in just a second, so let me pass it by, but it was sponsored by Brian from Nevada and John McCain, obviously from the state of Arizona, and it was enacted in 1996. And the goal was, as it says, health and safety of the fighters. Allow me to come back to that, because it involves directly the suspension list and some other things which we're going to be talking about and which presumably you're going to be voting on a little bit later. Then, at roughly the same time, a couple of years later, the attorney generals of many, many states formed a task force for boxing reform. It was headed ultimately first by the Attorney General of Illinois, but it shifted over to the Attorney General for New York, who was chairman during when it got completed and during much of the work. I was on that advisory committee for the task force, along with many others. It had many, many recommendations. And the reason I'm mentioning it, even though it was from the state attorney generals, was that it was led directly to the Muhammad Ali Act. It was something that was looked at carefully by the folks that ultimately drafted the Muhammad Ali Act, and it was a guide. But in the meantime, there was another federal action. It was United States versus Bob Lee. Bob Lee, who I mentioned before, head of the IBF at the time, was charged with fixing the rankings for money, bribery essentially. They charged him with about 36, in fact not about, they charged him with 36 different counts. He ultimately was convicted of 6. The convictions involved racketeering, money laundering, and he spent several years in jail. The import of that was, frankly, to put the fear of God into the boxing community. Oh my God, people can go to jail for doing bad things. Remember going back to International Boxing Club, even there, they broke it up, but nobody went to jail. Here, a head of a major sanctioning organization went to jail. And there is no question that that had a major impact on people's actions at the time. There may be people that forgot about that, but it had huge impact. And it also had huge impact on this prosecution, by the way, went on for quite some period of time. There was an indictment and investigation first, which was unfortunately very public. Somebody leaked a lot of information they shouldn't have, but everybody knew all about it before the indictment and before the conviction. So, John McCain, in 1998, introduced the Muhammad Ali Act, which you've heard me speak of for those who have been here many times in the past. I'm going to come back to that because it's linked to the Professional Boxing Health and Safety Act. Subsequently, Senator McCain concluded that the acts that had been passed weren't sufficient. And he introduced legislation very much like Kefauver did for a national commission back in 2002. There were hearings, but the legislation went nowhere for a couple reasons. One was, I will tell you that the Professional Boxing Health and Safety Act and the Muhammad Ali Act were uniquely the product of the influence of John McCain. I attended hearings where there were a lot of empty seats by senators who did not show up. I discussed that with Senator McCain, who said there's a couple of things that you should never do. The old standard, you should never watch sausage being made nor legislation. Well, there wasn't a great deal of interest by other senators, but Senator McCain had the influence and the power, he was head of the Commerce Committee at the time, to get through this act, the Muhammad Ali Act. It was created in 2 parts, in the sense that, as most legislation, there was the Senate version of the bill, and the House version of the bill. I worked very closely with the McCain staff on the Senate version, not so much on the House version, so I say all the bad things about it came from the House, not the Senate. And there are some bad things about it, so some incomplete things about it, but it was a step forward. So, with that being said, in that capsulized history, let me talk about the purposes of the respective acts. John McCain and Ken Nahagian, his chief aide at the time, wrote a law review article, and some of what he wrote is included on the slide before you. You can see that the purpose of the Professional Boxing Safety Act was to protect the health and safety of boxers. Now, I worked on that act as well. One of the things, and we're going to come back to this at the end of this little presentation, one of the things which was of crucial importance was the suspension list. Now, there was a commissioner at the time, Don Hazelton from Florida. How many people recognize, not you, Greg, not you, Mark, recognize the name Don Hazelton? Okay, so some do, and that's good. That means you're old, folks. It means you're getting older as we sit here. Okay, Don Hazelton was commissioner in Florida, later was a commissioner at Miccosukee when they were active. He created a suspension list. He ran it himself out of the state database in Florida. It was not, people weren't compelled to put names in it. It worked to some extent, but it didn't work to the extent it needed to because commissions simply were somewhat disjointed and they didn't do what they needed to do to get names on there. So, one of the major purposes of the Professional Boxing Safety Act was to make, thank you, was to make the suspension list mandatory. Now, when this provision was being drafted, it was mandatory that folks put fighters that were suspended medically on the list, and if they were suspended for disciplinary reasons, as sometimes happens, they were to put on the list. Medical suspensions were required to be honored. If they were disciplinary suspensions, there was a right of appeal, which to the best of my knowledge, and I'm pretty sure I would know, has never been utilized by a fighter, but there was a right of appeal to the ABC because there were commissioners in those days that proudly proclaimed reasons for suspensions which were not legitimate. So there was a right of appeal for a disciplinary suspension, but not a medical suspension. Not much thought was put into what constituted a license. I think that we, and this was a provision I was directly involved with, assumed, because it also focused on the federal ID card. This was the beginning of the federal ID system, that they were interchangeable terms, the federal ID and licensure. That has since come into question, and we're going to be addressing that issue a little later because some states, their attorney generals have suggested limitations on their authority to suspend and on the duration of suspensions, and we hope to be able to resolve that issue by the end of my presentation and Mike's comments at the end. It also put in some degree of conflicts of interest prohibitions, in this case regarding promoters on one hand and commissions and commission representatives on the other. Now, that leads us to the purpose of the Muhammad Ali Act. Remember, we talked about one was primarily health and safety, primarily oriented, and the second was business oriented. I'm not going to spend a lot of time. One of the things that I'm going to ask the ABC to do is there's on the website, the ABC website, there's a recitation of the Muhammad Ali Act. But there's something missing. Mike. Listen to this, please. There's something missing. For whatever reason, the title, there's a part of it that's just plain missing. It launches into the definitions. That's where it begins. But there's findings. And in order to understand either the Professional Health and Safety Act or the Muhammad Ali Act, you have to know what the congressional understanding was and what the findings were. So I would ask that the ABC include the findings which underlay the Muhammad Ali Act, and which in fact were voted as part of the Muhammad Ali Act by Congress, because that provides context for you to interpret these acts. And essentially, the Muhammad Ali Act addressed some ills. They created, well, I think the most notable provision, and that could be debated, is the provision which created a firewall between managers and promoters. Don King calls that the anti-Don King, and he has, in my presence, the anti-Don King provision, because he had his son as the manager of all of his fighters at the time. But it didn't matter. There were a lot of relationships between promoters and managers which were way too close, to the detriment. Now, it's important for you to understand the difference between a promoter and a manager to understand the Ali Act. A manager has a fiduciary duty to his client, the fighter. A fiduciary duty is the highest legal duty you can have. A promoter, which has a contract with a fighter, has a duty of good faith toward the fighter, but not a fiduciary duty in most cases. And it is up to the manager to protect the interests of the fighter, no matter how friendly the fighter may be with the promoter, or the attorney may be for the promoter, or the manager may be with the promoter. There is an independent duty to protect the fighter. Now, frankly, I'm involved in a major case right now where that was forgotten, and everybody got along until they didn't. And then it turned out that the duties were merged, and that's not the way it's supposed to be. There were restrictions placed on the ratings organizations. One of the things that was supposed to be objective ratings criteria, and I've talked to Mauricio about this maybe 10 minutes ago. One of the reasons why you have so few unified champions right now is if you look at the ratings, they're all over the place. So one would question how objective the ratings criteria are. But the goal was there, it just never happened. Now, I sent out earlier in the last week, and I hope you all got it, basically this presentation. I have been told that my time is going to be truncated, so I'm not going to go through all of the provisions of the Muhammad Ali Act. Yes, I'm still not even close to done, so. Andy? Okay, Andy says go to it. And he's one of the people who's dealing with the next issue, so I will go to it. We talked about the purposes. Okay, the first provision from the Muhammad Ali Act, and I've only taken out those things which directly relate to commissions or the ABC, but primarily, is the regulation of boxing events in places in the United States where there are no commissions. The law requires that a commission supervise an ABC commission, as it turns out, supervise the bout if it's in a jurisdiction. Now, since the act was passed, there are a lot more jurisdictions that have commissions than then. But it was very significant that be done because, you know, you had fights all over the place. And sometimes promoters were doing some pretty strange things. There was a promoter, for instance, ultimately he was from Philadelphia, but the promoter actually served as the referee for the fights, something that was not exactly neutral. The safety standards were promulgated. Now, these are now way, way, way below what we, in my experience, actually do. But in those days, this is now from the original Professional Boxer Health and Safety Act, there were no requirements whatsoever. Most of the states didn't have ambulances. Many of them didn't have doctors at ringside. Things were bad. And minimum standards were promulgated. They required that medical, the doctors be there, EMTs be there. It doesn't specifically say, and it should have, in my view, that ambulances be there, but there were states that lobbied vigorously against the requirements that ambulances be present. Is there any state here that does not require an ambulance on site? God bless you, because back in when this was enacted, you would have had about a third of the states raising their hands. So progress has been made. Of course, the ABC's medical standards do require an ambulance. It's not within the scope of my speech to talk about medical standards. They have to be looked at pretty carefully and made a lot more uniform. But this was a start. This was a start. This takes us now to the section that requires the boxer ID. Again, I told you, there were no such things as a national boxer ID when the Health and Safety Act was passed. In fact, many states didn't require a license back then. You know, they looked at you, they knew who you were if you had a name, but they didn't license you in the same sense that they license you today. So the Professional Boxer Health and Safety Act did a couple of things. It required federal IDs. My papers are blowing all over the place. What's on my screen here is not the same as what I'm talking about, so you understand. It talks about how they are to be issued. You all do it, so I don't need to go through that. But crucially, it talks about the adherence by other commissions to the adherence of the other commissions to the suspension list. I've already touched on that. You have to adhere to a medical suspension. You should adhere to a disciplinary suspension subject to the right of a boxer to appeal to the ABC. Again, no boxer's ever done that. It requires, and this is something that Greg always talks about, he picks up his head real quick. It requires that boxing results no later than 48 business hours after the conclusion of a fight, get reported to the boxing registry, now BoxRec. It's crucial because, as Greg pointed out, you can have somebody fight on a Friday, and then a couple of days later, and maybe a different sport, maybe not, they fight somewhere else, and if you're slow, that could cause a serious problem. He referred to a situation where there was a knockout. Now, everybody knows there should be a mandatory period of suspension substantial after a knockout, but it only works if other people know, other commissions know that, thank you. He's back there saying, you gotta shut up, you gotta shut up. He has something he very much wants to get on the table. It only works if everybody knows about it. I spoke about some business practices. Now, this was a section yeah. This was a section that came in through the Muhammad Ali Act. One of the things that were used to oppress fighters, and again, in a different way, I spoke to Mauricio about this. There's such a thing as a mandatory system, where if a fighter is typically number one, they become the mandatory contender. They get to fight for the championship. The problem is that back before the Muhammad Ali Act, certain promoters would extort contracts, promotional contracts, out of the fighters that were fighting for the championships. So the Muhammad Ali Act, oh, by the way, I mentioned promoters, but it was also television networks, HBO and Showtime, both. So and this was a provision that I worked on, this prohibited that. You couldn't extort future rights from a mandatory in order for that mandatory to fight for the title. And it limited future rights to a year for non-mandatories. Non-mandatories is a little different because it's a voluntary, obviously, as time showed. It's a voluntary. You don't have to fight Andy Ruiz. Joshua didn't have to fight him. He chose to. His promoter could get up to 1 year's worth of rights on Andy Ruiz as a negotiated part of the deal. But if Andy Ruiz had been the mandatory, he wouldn't have to give up any rights whatsoever. He becomes a champion, and he's free to fight whoever he wants. It was a major change in the business structure of boxing at the time. This involves the commissions quite a bit, which I know is honored in the breach. All contracts, there's a lot of disclosures that have to be made to a commission. Some of them are. You have to disclose what you're paying to the sanctioning organization, the officials. If you're taking any money out from a fighter, and sometimes there's a loan or something like that, that has to be disclosed to the commission. But I know, as much as I am alive, that the requirement that all contracts relating to a specific bout be given to the commission, I know that that's not honored by probably 90% of the promoters. They've forgotten totally about this, but as commission members, and I think New York's pretty good about this, uniquely so, you got to know that you're supposed to get all the contracts that relate to that bout unless you have an open Public Records Act, which would allow them to be public, in which case those contracts are to be filed with the ABC. That's part of the federal law. That information is also available to the State Attorney General if the State Attorney General requests it. Most of you have Deputy Attorney Generals that represent the commission, so that's sort of a, whoa. You can see that there's quite a breeze up here. I was going to say, most of you have deputy attorney generals that represent the commission. It's not important. Let it be. Now, this is something rather important. There was a time when the officials were not appointed, believe it or not, by the local commission in many jurisdictions. The act required that the judges and the referee be appointed by the local commission, and this is worthy of some mention. It does not say that, for instance, if it's a championship fight, the ratings organization cannot make recommendations. A lot of times those recommendations are very important. They're important to the fighters. They should be important to you. Hopefully they're good recommendations. But you are not bound by those recommendations. If your responsibility is to make sure you've got the best officials. Many times those officials may be from out of state. Let's not play Homer type situation, which is where I think the ratings organizations can come in. But it is your responsibility to approve the officials, and they must be trained officials. That part was necessary at the time. I think all of our officials are properly trained now. They may be good officials, they may be bad officials, but they are trained. We talked about the firewall provision earlier, which for some reason is blank here, but I've gone through that with you, where there's a firewall between the promoter and the manager. There are some exceptions, one most notable really, and that is if the boxer is his own promoter. That is not prohibited. He can manage and promote himself. That's exactly what I'm up to. Private right of action. You've got enforcement can be by the U.S. Attorney. There have been numerous referrals by the ABC over the years that I'm well aware of to the U.S. Attorney's Office. Not one has been acted on at all. They consider this to be at best a misdemeanor, and they're not going to spend the time on it. It's unfortunate. That is not what was contemplated by the act, but their priorities are elsewhere. State attorneys general have the authority to enforce the act. Your attorneys have the authority to enforce the act. So don't rely on the feds. If you know there's a blatant violation, please ask your attorneys general to enforce it. But significantly, and there's been a lot of litigation, the fighters themselves, when they're negatively affected, have the right to enforce. There's a private right of action. The fighter, if he's been injured, gets attorney's fees. And there have been a number of actions over the years where a fighter has alleged that a violation of the firewall has hurt him, and sometimes it results in the contract, promotional contract, managerial contract, whichever, being voided. I am unaware of any situation that resulted in damages. I wouldn't be surprised if there is, but I just can't tell you that there is. Now, I should say, I'm looking at Tracy, and a thought occurred to me. This act, these acts, apply only to boxing. They do not apply to MMA. So, and Tracy from Bellator is looking at me saying, oh man, I'm glad we don't have to deal with all this stuff. But from a federal perspective, this only deals with boxing. You can't give, if you're a promoter or a representative of a promoter, you can't give things of value to officials. This, again, overseas, for quite a while, it was de rigueur that things of value were given by some promoters to officials. That was a real problem. It has been a problem here in the past. I hope that that has stopped. I have not heard of it recently. The one thing you can do is a gift or benefit of de minimis value. I can ask Darrell Peoples, who's currently president of the IBF. I can take him out for a beer, not much more, but a beer. We actually often bet about various things. He owes me about 50 beers. He's not here, so I can tell you he's often wrong on picking fights. But that leads us to an action item for you. Who can tell me who this is? I can't hear you. What? Yes, sir. That's terrific, because I didn't expect anybody to know. Stephan Johnson was a fighter who lost his life in a fight, as a result of a fight, in Atlantic City, New Jersey. He's lost now in the mists of antiquity. When I say that, when I was preparing for this, I tried to find a still picture on social media, through the internet, of Stephan Johnson. I couldn't find one. This is a still shot from one of his fights. He lost his life because people didn't adhere properly to the suspension list. He was put on the suspension list by Ontario, which is part of the ABC. They had a very good commissioner at the time. Another state improperly took him off. He had a brain problem. He did not have a clean CAT scan. He fought in New Jersey. He was not on the suspension list. In fact, had fought one other place before. And I was there. He was on the undercard of a major fight. And he was winning the fight. It wasn't a particularly tough fight. And I saw that young man collapse. Just collapsed. Not from a result of a blow. Just went down. And he had a brain bleed, which should have been picked up before. It wasn't. And in major part, there were other contributing factors, but in major part it was because people did not adhere to the suspension list. The kid should never have been taken off, and was. So that leads us to a discussion about the suspension list. But I put his picture up because it illustrates the consequences. Now, some of you know, many of you don't, that I've had an active set of correspondence with New York recently about my view that the federal law and their state laws as well allow certain people to be put on the suspension list when they, for instance, Jarrell Miller as a concrete example, three-time loser on drug test just before he was supposed to fight Anthony Joshua. The Deputy Attorney General in New York did not agree with me. He is not on any suspension list and is certainly being talked about as fighting in the very near future, actually. Additionally, I know that there are fighters that are being denied the right to fight for medical reasons by a local commission and not being placed on the suspension list. Just 2 weekends ago, there was a fighter in the state of Washington who the day of the fight was rejected for medical reasons. If it was a medical reason, he should be on the suspension list. He isn't. I don't know all the details of that, but I know that he's not on the suspension list. And I know for a fact that many commissions are saying, look, Guy, I don't really want you to fight here, but I'm not going to put you on the suspension list. Please, just don't come back here. That is not what we had in mind when the suspension list was formalized through the Boxer Health and Safety Act. It was to protect boxers and to allow the enforcement of disciplinary action against fighters. Two separate but good reasons, and that it's really at the basis of the ABC, unified action. So when this came up, Jarrell Miller was a triggering event, but it isn't the only event. There's the health and safety side of it too. Because different attorney generals who have absolutely no understanding of the federal act, and I'm not charitable toward them, no understanding of the background, no understanding of the suspension list, have given the commission's contrary advice, Mike asked me to promulgate something that would allow the ABC to act. ABC didn't have authority. I think it did act once, just sort of unilaterally, but it didn't really have any authority. Well, one of the ways to do that is the suspension list is the property of the ABC. The federal ID system is conducted through the ABC. So we have come up with language, and it'll take 4 years to implement this so that the ABC can do it, where a state, for some reason, feels that it does not have jurisdiction. We're not talking about the ABC intruding into the states. But if a state feels that it doesn't have jurisdiction, they may very well want to take action, but somebody is telling them from above that they can't. It allows the ABC to place a fighter on the suspension list. Actually, it allows 3 different entities. One is the ABC. Second is the state in which the infraction or medical situation arose. And the third is the state issuing the federal ID. Because remember, if you go back, I said that at the time this was enacted, we really weren't making a distinction between the federal ID and a license. So, in order of that, I just gave it to you, but I gave it to you in the wrong order. It should always be first jurisdiction with the state where the issue arose. The others only apply where the state can't act. So that is the change. The change is to expand the ability to put fighters on the suspension list by consent, because they consent when they fill out the form. It's a change in the language on the identification form application, ID card, and it allows the ABC to take action in, and it will only do so, I know, in egregious situations. So, and I know that, look at that. Let it go, it's not worth it. You can see the fan is up here. Let it go. So, I know that, yes, I know. I know that Mr. Mazzulli now wishes to have you vote on that change. And Mr. Serb is back there going, so, go.
All my career. If Pat wasn't there and
Are these yours, bro?
a few of us, that federal law would have never gotten passed. That right here, that's the man right there. I bitch at him, I complain to him.
You bitch at.
We have telephone conversations that are just unreal and they're wrong.
Let me give you a little history.
That's the man right
Let me give you a little history on why I wanted this done. It had nothing to do with what occurred in New York. It had to occur what happened in Arkansas. And I'm going to talk about it, and Arkansas is not a member in good standing. And all I know, you guys are going to be flabbergasted when I tell you the story. And I don't know if you saw anything in the papers over a bit, but in a nutshell, what happened was Arkansas let a fighter fight on the card with HIV, documented HIV. I took it upon myself to suspend the fighter. The state he fought previously in, the commissioner gives me a call and tells me that he's fighting in Arkansas and he's got HIV. And it's documented, and it's a result that says a positive test. So I call up Arkansas, the health department, and I speak to the gentleman who knows absolutely nothing about nothing and doesn't care about nothing and doesn't care about boxing. He's the director of the health department. I don't know if he knew what HIV was. But with that said, we got into a conversation, and I explained to him, on this date, you have a fighter who's fighting with HIV. My cohort, the lady in red back there, Lydia, who was on the commission at one point and was not there any longer, warned them as well. They just didn't care. They supposedly they had no blood testing. They had no testing at all. They supposedly requested blood testing. The gentleman falsified the test, like to the point where my third grader would realize it was falsified. I mean, anybody with a brain in their head would know that they doctored the document, and he fought. So with that said, I put him on suspension as the ABC representative. I called Pat and Cowboy, and they said, "You can't do that." I said, "Bullshit, I just did it." So now I'm trying to cover my ass after the fact. So that's where this came from. Frank, yeah, Frank. Yeah, that kid was denied in Florida because of that. So, and now we got Arkansas, who's not a member in good standing and don't care. And so this is where the frustration comes from. I mean, that's why 4 years as president gets kind of rough when something comes down like that and you realize, holy cow, we could be sued by, I feel sorry for the fighter. And at the end of the day, some representatives from that department were laid off and they were moved and shuffled around. But as of today, they still have no idea what they're doing in Arkansas. And they're not present right here. Michael, intern, go, put the phone down and go. The intern's name is Nick, just so you guys know. That's Nick. He's been with me for 3 years.
When we worked with Senator McCain on the bill that ended up failing, we had initially put in those minimum medical requirements that you showed up there. And part of the bill that unfortunately failed would have expanded those minimum medical requirements, which we have been trying to put in since 1997. So I implore, if your state commission or your tribal commission still does not at least have the minimum medical standards, which were a physical exam, an EKG, an dilated eye exam, a CT or an MRI, and an HIV, Hep B, Hep C. That was the minimum we had all agreed back in '97, and then for that bill in 2002 that we worked so hard with Senator McCain on that unfortunately didn't pass, then you need to re-examine your regs. Because at the very least, we looked for minimum uniformity, and some states are still not requiring blood tests. And it's getting a little ridiculous. So at least if you don't, let's try to move everybody up to the minimum if we could.
After what occurred in Arkansas, they do require blood tests now, believe it or not. So we're going to bring Cowboy up here. Hurry up, Mark.
I just want to talk. A lot of times what we deal with is, has anyone in the room ever dealt with a falsified medical? Raise your hand. Everyone's dealt with it, but everyone else has their own little procedure for how to do it, right? So what I'm trying to do, because I'm dealing with an issue in New Jersey right now, is I'm going to try and develop something off what I'm doing now to make more of a uniform way how we address a falsified medical, just because it's become a rampant issue. And from a law enforcement standpoint, if they falsify something with me, I can arrest them. You guys, many of you don't have that kind of power. If that's forgery, as far as I'm concerned. So what I'm going to try and do is what I'm working with New Jersey right now, because we had an issue with one of their fighters. I'm more than likely going to do that, and then I'm going to create a process and maybe send it all to you guys and take a look and see if that's how we want to address people that are falsifying medicals. I know New Jersey's going to take a pretty heavy hand with regards to what they're going to do with this once I forward them all the information. So, thanks.
I'm going to do the motion right now. I want to motion that we adopt the new federal ID, which will provide the ability for the new president to suspend fighters throughout the country for if the fighter is not licensed in the state that they were either tested positive for or.
Many states won't take jurisdiction if it's scheduled in that state. There's some states that don't have.
They don't.
It's really
Okay.
only if the state doesn't feel it has jurisdiction.
That's my motion.
Is it fair to say, Mike, that if I summarized it, that what your motion is to adopt this new, the new federal ID card application?
Correct.
Okay. Which includes all the stuff that we've been talking about up here. But if you've got, that's what the motion is. Is there a second?
Absolutely.
Kim Sundler.
Starting the day off right.
Is there any discussion on the new federal identification application? Any discussion? Yes, sir. I'm sorry, I can't see who it is exactly. Oh, it's Minnesota.
Hey, thank you, Matt Job from Minnesota, an attorney, so always hated. No, I had a question. It says in number 6, the Boxer agrees that the following entities have the authority to place the Boxer on the national suspension list with cause and subject to due process. What's the due process? Is it Mr. Mazzulli, who I met last night and respect decides he gets to? Is there a process in place?
Okay. All states, they can do an interim suspension, but there's not a state out there that can do a substantial suspension without giving the fighter a right of reply. I've, on other occasions, gone through that, but the fighter at minimum has a right of reply, and frankly, I would say a right to a hearing. It all depends on the circumstances. As you know, due process is a flexible concept, but you have to just notify the boxer and give him a chance, because weird things happen. Sometimes, in New Jersey once, blood samples got mixed up, just got mixed up. New Jersey did the right thing and threw them out, but there has to be some right of reply because it would be totally unfair otherwise.
Oh, right. I understand that. So my question is, does the ABC, if they're doing the suspension, what's their process? Are they do they notify the person and give them the right to reply?
Pat English is
I'll bet you $1 they'll contact me, and then under the circumstances, we'll talk about what processes do.
Okay.
Does that answer your question? Is that acceptable to you?
I'm raising the issue. I'm relatively new, so I defer to the group, but just wanted to raise that issue.
There would be a strong recommendation from the legal committee to not take any action until we had full due process in place.
Okay.
Mr. Serb is recognized.
The way it was, when the federal law got passed, you could be suspended, and if it was non-medical, then, you could appeal to the ABC. And so we ended up having we called it the disciplinary committee we had at that time. And the first case we had was a young man that got disciplined by Billy Lyons, who was 150 years old out of Mississippi. And he called Billy Lyons' wife a name that he shouldn't have. And Billy Lyons suspended him and put him on the suspension list. And then when I was president, that kid appealed. And we had to hold the hearing, and we took it from like 3 years to 60 days in a written apology. We had to send them. But we only had that one and one other case in the 7 years that I was president, so that committee kind of wasn't working. If we do this, then that committee needs to be revamped again. And so that kid would appeal to this committee. This committee would have to hear that case. In our case, we did it by telephone, and, you know, if you wanted to be present and have an attorney. So that, we would have to reinvent that disciplinary committee if we're going to do this.
All right, and yes, that's right. The disciplinary committee is a standing committee, and absolutely it would have to be, because there would have to be due process. So, all right, any other discussion on the proposal is just simply changing the form, and we got to, I'm not trying to shut everybody down, but we got a bunch more on the agenda here. We got a few people over here.
Hi, Jim Grogan. I am concerned also about the due process provisions. How do we enact this without explaining what the due process is? I mean, taking a fighter's right to his livelihood away is a serious matter, I think. And I'm just wondering, how do we enact this without knowing what the process is and what processes do? My understanding of due process has always been, we let you speak before we rip your face off. I'm also an attorney.
Answer that, because I know the legal standard, and I already articulated. There is no one size fits all. Very often, a fighter will say, I did it. I just want to send you a letter saying, please don't hit me for 2 years, hit me for 60 days, or whatever it may be. The due process that he is entitled to is a lot less than the fighter that says, this isn't me, this wasn't my blood, I have substantive defenses. So you have to give flexibility to the hearing group, disciplinary committee, to tailor the due process. And there's a slew of cases that say just that. The process that is due is dependent upon the circumstances. So it's impossible to define, other than to say it will go to the disciplinary committee for due process. And you have to have minimum standards, that's true, but the standards are very different depending on the circumstances.
So I think part of this is the next president, whoever that is going to have to make sure that the disciplinary committee is on the ball and ready to go, ready to move forward with this based upon getting this new form in.
Do we want to table this and discuss and set up should we set up a process, due process, before we implement this document? Is my question. Necessary.
That's a good idea before you
Yes.
send it to the
Yes.
market. It's your motion, Mike. Do you want to move? Do you want to move?
Let's vote on it.
All right.
Wait,
All right.
I'm sorry, please go ahead.
We have further discussion.
Yes, so before we table it for there's 2 points I'd like to bring up. On number 1, since BoxRec has taken over the compilation of all of the IDs, they're so easy to see and find now. Can any state issue an ID, and can any state renew an ID? Because that's one of the largest bottlenecks that we have.
That was a question I asked the chairman of the boxing committee yesterday. He didn't answer it.
Chairman?
I have no problem with that.
Specifically, in federal law, the ID is given to the boxer on the state he resides.
Okay, so that's the initial issuance. What about renewals?
Renewals, Pat, what do you think? You think there's some leeway there? I don't
Please, please, please.
It's not addressed, there's leeway.
If a fighter moves, if somebody
Yeah,
moves,
yeah.
we're talking about renewal.
No, I'm saying, if that
No,
is
they
not
renew with their original state. Let it be on your side.
Since that's not addressed, and it's not prohibited, say yes, you can renew somewhere else.
No. I'm with you.
Right. The Act addresses the original license. It doesn't address at all renewals. So given that it doesn't address it, it would not appear to me to be prohibited to have the renewal at a more convenient state, perhaps where he's about to fight. Now, I would also note that it also says that where there's no commission, it's where he's doing his first fight. And if you're a foreign fighter, and many of you have foreign fighters coming in, you have perfect jurisdiction to grant the license. Excuse me, the ID.
Standard operating procedure, as far as I'm concerned, if somebody shows up to your commission and they're going to say they have an expired ID, you'll confirm with the initial commission that they do have the ID, that it is expired. You'll allow them to fight that one time on the expired ID, then you suspend them, and then they are then to return to their home commission to renew their ID. Correct?
That's been standard for the last 12 years.
That was my question.
I know we're all very easy to work with, right? That's not always the case. Some of these fighters, at least the sob story that I get, is that, well, I've been trying to do it, but they won't allow me to do it. They have to go there.
Some commissions are requiring them to physically show up to do that. I get that, but I mean, if you're verifying who they are with their driver's license and their ID and the ID's expired, why not simplify the process all the way around and do that? I mean, if you can actually verify who they are, why not simplify it?
All right, we're off topic now, though. I think we got the motion on the floor is about this new federal ID form, and I think we've gotten off topic, and I'm going to rule this area not germane. And is there any other discussion on the motion that's on the floor? Well, and her question's been answered. She can do it. So. No, there has not been a motion to table it. President Mazzulli, just in case there's any misunderstanding, he did not move to table it, did you? He's moving to have a vote on it right now with the understanding that we'd move forward and have and make sure that the disciplinary committee is ready to go before any suspensions are done.
You have to understand, too, this is a 4-year process because everybody...
You want to vote on it?
The old form.
Okay, there's a motion to end discussion on it and have a vote on it by Mr. Foster. Is there a second to end discussion? Second by Scott. Sorry, Scott. We have a motion to end discussion and a second. Is there any discussion on the motion to end discussion?
No.
All in favor of ending discussion and moving to a vote, signify by saying aye. All opposed? The ayes have it. We've ended discussion. We'll move to the question of whether to adopt the new form that has been presented and moved by President Mazzulli, seconded by Kim Sumbler. We will go to a voice vote initially. All in favor of adopting the new form for federal identification, signify by saying aye. All opposed say nay. The ayes have it, and it is passed. Unanimously.